This is the NP Business Matters Podcast, episode number 8, with Melanie Balestra on AB-890 in California. Hello and welcome to the NP Business Matters Podcast. I'm your host, Barbara C. Phillips, nurse practitioner and founder of Nurse Practitioner Business Owner and the Clinician Business Institute, where since 2007, we've been providing education, resources, and support about the business of being a nurse practitioner. And to learn more, please visit our websites at npbusiness.com and theclinicianbusinessinstitute.com. Now, before I get into today's episode, I want to invite you to do 3 things. First, head over to iTunes or wherever you listen to podcasts and make sure that you're subscribed. Secondly, please leave a review because it helps people find our podcasts, and share it with your colleagues. And finally, if you visit npbusiness.com/podcast, you'll find the show notes not only for this episode, but for each and every one of our episodes, plus the resources and any other links to help you with the information that you are looking for. So today I'm talking with Melanie Balestra, a nurse practitioner and an attorney in California. Melanie works a lot with nurse practitioners, is known for a lot of her work, works a lot with the California Association of Nurse Practitioners, which we'll talk about later in the episode. But right now we're talking about AB-890. So AB-890, which was passed and signed by Governor Newsom at the end of September 2020, is being touted as a full practice authority bill or law. And it isn't that, as you'll hear when we talk. In fact, at one point, I say to Melanie that this sounds even more restrictive. And I believe that it is, but you'll have to hear about it and make your own decisions about that. But it is anything but full practice authority. So with that, let's get into the interview on the NP Business Podcast today with Melanie Balestra. I am so glad you've joined us again today. And just to kind of do a little bit of a backtrack to let you know, there's been so many people who've gone back to the ABC recording that we did earlier this year and have gotten a lot of really good information, especially since more states are implementing that. But today we're going to talk about AB-890 that I keep hearing everyone says it's full practice authority for nurse practitioners in California. It was signed by Governor Newsom at the end of September. So what can you tell us about what this really is?
Okay, it is not, eventually it will get to full practice authority. At this point in time, there is the only time they mentioned is by 2023. The board will implement all these things to be done. And just before I start this too, I want to mention, I don't know how many MPs are aware that the president signed an executive order in 2019, which wanted to eliminate all excessive supervision requirements that prevents APRNs and PAs from delivering appropriate diagnosis and quality care. And he also wanted to provide for equal pay for PAs and MPs for equal services. And I don't think a lot of MPs know about this, and it was supposed to be implemented within a year. But then again, the states have come up what they want. But bottom line, I don't think many people realize that the president is very supportive of MPs and PAs. I don't think that's ever come out in the news or anything else because it's not considered that important, but he is.
Right. And that was actually signed. I just did a recording with someone that hasn't been released yet, but he had signed that apparently back in April and again in October. But again, how that's going to be implemented, on a state by state basis, with all these varying rules is going to be very different.
Yeah,
So,
it's a shame, but federally, we are far more supported federally than we are, well, especially in California. We're not supported very much, but we certainly, as we've seen, have, federal support. Uh, but like I said, I think I've said before, in law school, you learn that federal law supersedes state law, but in actual practice, unfortunately, that does not happen.
right, right. I mean, I'm in Missouri, so
Hmm.
we may even be further behind California. Well, at this point, we are further behind
Behind.
California. At least now you've got some kind of legislation signed. So,
Hmm.
but what does 890 actually allow a nurse practitioner to do?
Well, this is it. It's complicated. They are going to have a nurse practitioner advisory committee. We did want to get our own board because the PAs have their own board, but the BRN did not like this, and the CNA was not in favor of this. And of course, the CNA is very controlling. California Nurses Association, which is a union association in California. So they will appoint a committee, and the committee is going to be made up of two physicians. Make sure I have this right. Um, Two NPs and one public member. And the two physicians will have to have demonstrated that they have worked with MPs. And then the one public member, I would imagine, will be somebody associated with a union in some way. And the BRN is the one choosing these members. So I am concerned because thus far the BRN has chosen members of the BRN that are in line with the way they think. So I don't know what they're going to end up with. The other thing is that this advisory committee is going to be providing recommendations or guidance to the BRN, considering disciplinary actions against the MP. And hopefully this will be better because at the present time, our BRN doesn't really understand what MPs can and cannot do. So this is a problem in itself. And then they will authorize MPs who meet certain education requirements, which they will define, and experience and certification requirements to perform in certain settings, organizations, or specified functions without SPs. Now, what in world does this mean? Okay, let me get to that because it's going to be interesting. You think we're going to be able to go forward without anything in writing, but we're not. So what they're going to do is name the functions that we can do in certain settings, such as a hospital or a physician's office or that kind of thing. And we're going to have to meet those requirements for those functions, and they will be diagnostic function. It goes into detail, laboratory functions, interpreting those tests. So those will be specified.
This
Okay.
sounds more like protocols.
You, yes.
Oh,
I am not a big fan of this law.
yeah.
Yeah, so everyone thinks they're going to be practicing without anything. But the other thing that it discusses specifically too, you're going to have basically protocols for when you refer a physician to another, or when you refer a patient out, or what is an emergency situation. So those are protocols that are going to have to be written. Okay. So we're not going to do without protocols completely. And then they will decide whether they will accept a national certification exam or not, or this may not be sufficient because what the board wants to do is have their own exams. Now, it doesn't say a general exam or whether going for everything, like will there be a PMP, an FMP, like we have for
Mhm.
national. It doesn't specify that, but you will have to pass the national and you will have to pass the board exam in order to be certified. But you know they have to 2023 to develop these exams.
Okay.
And I'm not sure who is going to write them, what their background is going to be, but I don't quite understand why they don't feel the national certification exams are sufficient. But this is what they want. And they want it's the Office of Professional Examination Services. I didn't even know there was that office, but there is, or something equivalent to this office. Since I don't know much about the office, I don't know what would be equivalent to perform an occupational analysis of MPs performing the functions specified. So, what this means to me is they are going to be sending people out to where MPs are practicing and evaluating those MPs to see if they can perform the specific functions that they have mentioned. Okay. So this is all going to be done by 2023, January 1. And they're also stating that, as I said, MPs have passed a national board exam and any supplemental exam. And they can also provide documentation that educational training was consistent with the standards established by the BRN. And to this, I see more of right now, our board says you can only perform what you learned in your MP program. So, like if you're doing injections, joint injections, or pellets, or anything like that, you have to be able to demonstrate that you had the didactic, the clinical, the evaluations, and the experience to do that in writing. Otherwise, if you go before the board and you don't have any of this, they will say that this is outside your scope of practice because it wasn't in the program that you went to.
So let me.
Yeah.
I'm trying to figure out what the advantage to any of this is, but with what you were just talking about, so many of us, we get out of our programs and then we go and learn in other programs,
Mhm.
whether it's some kind of a continuing education programs, sometimes certified, sometimes not.
Mhm.
So are they actually saying that those would not qualify because it wasn't in the original nurse practitioner program?
No, they would have to have those proof, those certificates and everything.
Okay.
So
Okay.
what it's saying basically, like if like in peds, I learned a lot, not through just a certification, but working with a pediatrician and that type of thing. You learn to do
Mhm.
different things.
Right.
Okay, unless I can show that, who the physician is that taught me, how many hours we spent, blah, 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 I really couldn't do those procedures because they were not in my MP program. Okay, so that needs that specificity. Okay, I'm going to my cheat sheets here because this is it's so complicated. Um, and then if you want to get into independent practice eventually, you have to go through a transition in practice of a minimum of 3 full equivalent years of practice or 4,600 hours. So you have to practice under like I'd have to practice under a pediatrician for 4,600 hours or 3 years of practice. And he or she would then have to evaluate me and state that, I was safe and I could go independent practice. However, if you meet all the above requirements, you may practice, including but not limited to performing the authorized function in one of the following settings or organizations in which one or more physicians practice with the MP without SPs. So, in other words, I'd have to go through the transition of doing all that. Then I get to where I can practice without standardized procedures in the following settings: in care agencies that have governing bodies, um, that are pursuant to the law, which would be like a hospital, a physician's office, a federally qualified clinic, that kind of thing. Um, so you could do that kind of thing. But they are allowing us to, like if we're in hospital, we are eligible to attend meetings of the department to which we are assigned. We cannot vote, though, unless it's regarding determination of an MP privileges with the organization or peer review. So we can sit on the committee, but we can only vote on something that concerns MPs. Um, and what they've stated, MPs can perform the following with standardized procedures: order, perform, and interpret diagnostic procedures, radiologic exams, establish primary and differential diagnoses, diagnose, prescribe, order, dispense, and have an MA working. And we have to inform of what we've always informed patients, that we're not a physician. But now, if we have a Spanish patient and my Spanish is horrible, we have to say we are an enfermera especializada. Okay. And so if you did not say that to a Spanish patient, you could get in trouble. So what I will have to do, I mean, I'll literally have to write it down, because I don't speak Spanish. I can understand some of it, but I start speaking Spanish and suddenly everybody knows a little English. So that's kind of what happens there. And also, in hospitals, we are going to be, what they have are 805 hearings, and that's if you do something wrong in a hospital, the physicians report you to the medical board under an 805, what they call an 805 hearing. And so the same thing is going to be done for MPs, only it will be with the BRN. And personally, I'd rather go before the medical board, than I would the BRN. But this is something that the BRN is then going to have to become proficient at too, doing these kinds of hearings, which they don't know exactly. So, okay. Okay, I was wrong too. The NP Advisory Committee, it's four MPs, not two. Four MPs, two physicians, one public member.
Okay.
We are also going to be liable for Stark and kickback laws. So, in other words, if you practice in a practice and say you own part of a lab, or a part of something else that you're referring the patient to, then you are going to have to do exactly what physicians do, and that's is you're going to have to notify patients that you own a percentage of this, and so you can get a profit. So you're going to have to tell the patient they can go to all of these different places, and they
Right.
can choose. And that's something I've always ethically recommended.
Yes, I've
So
always done that.
yeah, so that to me is nothing new, but they seem to think it's new. um and the intent of the legislature for this, okay, is not to be an undue or unnecessary burden to license or practice for MPs. Now, I'm not sure why they consider that undue, or, it's just totally beyond me, because I think this is very much an undue practice. Let me get, I had these in order and somebody got into them. Okay. All right. And I've gone into what we can do with standardized procedures. Okay. You are going to have to put a notice in a conspicuous location accessible to public view that you are regulated by the BRN, and include the BRN phone number, internet website, and this has to be, and you have to mention where um, they can go to make a complaint against you. And this has to be in public view. You know, most like physicians, you have to have your license in public view, but you have to have all of this in public view, stating this. I guess they assume more people are going to want to sue MPs. I don't know. Um, MPs will have to have professional liability insurance, and this is something I recommend all the time, anyhow. So
Right,
that to
right.
me is no biggie. Um, and you have to refer to a physician or other healthcare provider if it's outside your scope. That's not new or different either. Okay. The BRN will issue a certificate to perform functions outside of settings and the organizations of an MP. So that would be like in an independent setting if they meet all the requirements that has been specified previously, you know, their certifications, the hours, and all of that. You have to hold a valid and active RN license and have a master's or related field, and they don't specify what a related field is, or a DMP. And you have to be in good standing for at least 2 years, not inclusive of the transition required. So you'd have to be in, so you would have like 5 years, 2 years where you're in good standing plus the 3 years. And the BRN can lower this requirement for an MP that has a DMP that is based on practice experience. So if you practice, you know, if you don't do just either a research study or something that doesn't include patients, if you do something that includes patients in your DMP, then they can use that as the good standing requirement and you can get your private practice. And they may charge a fee um, in an amount to cover the regulatory, which right now I pay, I think it's a little over $500 for all my licenses in California. So
Mhm.
there would be an additional license. And just in comparison, my bar license isn't that much.
Right.
So you're paying more to be an MP than to be an attorney.
Is that per year?
Every 2 years.
Every 2 years. Okay.
hmm Okay, so beginning January 1, 2023, if the MP holds an active certification issued by the BRN, they can perform functions specified outside of settings or organizations specified. So to me, if it's specified, then it has to be in writing. So in other words, it would say that I could do joint injections outside. I could do uh, pellet insertions outside, but it would have to specify what I could do outside. Now they may broaden. Right now, our scope of practice is it's not truly defined. Most states have a scope of practice for RNs and then a separate scope
Right.
for MPs. California does not. We're all with the RNs. So they are going to have to write these specifications out because otherwise the BRN can come after you and say, you know, you're doing something that is not specified outside your normal scope of practice. So they can go after you. So you're going to have to be very careful. You may be eligible for membership of an organized medical staff if you go through everything. And you may vote at the meetings of a department assigned if there is no conflict. So these are the things that you can do beginning January 2023. It does not specify, because I had an MP who works at the clinic I do, and the clinical director, we went in to do our yearly, update for SPs and everything. And the clinical director said, so and so said, we can just throw these out. We don't need these anymore. And I'm going, no, 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 no. You can't do that, because the bill does not say whether this is going to occur in 2023 or whether it may occur before then. So don't throw out your standardized procedures.
Okay.
Definitely. You want to keep them. Okay. And the MP shall comply with the following. Again, they shall not practice beyond their scope, evaluation, and training. So anything you do not learn in your nurse practitioner school, you must have these three things, or they will say that you're outside your scope.
Mhm.
And they're actually doing that now, because I've had quite a few, well, I won't say quite a few, but several MPs who are doing joint injections, and I have some that are doing stem cell injections, and I'm just, oh, danger, 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 because this is not something you learned in your nurse practitioner program. So you definitely need to, be able to specify how you were trained and why you are, this is within your
Mhm.
scope.
Mhm.
The MP shall consult and collaborate with other healing art providers based on clinical condition of the patient, individualized protocols and following circumstances. Now, this is what you're going to have protocols for according to this: emergent condition, acute decompensation, problem not resolving, and H&P or lab findings that are inconsistent with your clinical perspective and upon request of the patient. So you are going to have some kind of protocols on these to be able to show that these are the times that you will, refer the patient out. Now, the other thing that it does not mention is those of us who've been practicing for eons. Are we going to be grandfathered in? Are we going to have to take this exam they develop? I don't know. I have no idea. It says absolutely nothing about grandfathering in. And I think in California now, I think we have around 15, 16,000, might even be more MPs. So I've already gotten phone calls, from MPs who don't have masters that, went to programs. I think it was up in Northern California, Davis, they had a program, and that it's probably 25, 30 years ago, that didn't require a master's. And then Medicare, of course, came in, and Medicaid, saying that you had a master's degree.
Mhm.
Well, a lot of nurse practitioners function in a private practice, and it wasn't a specification for private insurances and that kind of thing. So I've been working under their settings. So they have called me and said, do I need to get a master's degree? Unless the BRN grandfathers these MPs in, yes, you have to have a master's degree.
Mhm.
So there's going to be a lot of questions like this coming up.
Mhm.
And presently, there aren't any answers. I know the people that were involved in making this bill, and the push was to get something through in California. Um, and their thinking was, even if we get something in really restrictive, we've got something in, and then we can, you know, uh, um, can't think of it, amend it
Right.
later on. But my experience in in legislative changes is it's difficult to change things. It is better to get a law in that you want, and if something isn't clear, to amend it at a later date.
Mhm.
But I mean, I'm sure you can see. how many amendments come in. And what I basically summarized it, um, what standardized procedures elimination takes place, when, where, how. Will there be grandfathering? If so, how are these decisions going to be made? And how are these evaluations going to be made? Are they going to be this people from this evaluation committee? Are they going to be MPs? Are they going to be physicians? Are they going to be what I call people off the street? Um, who have just been trained to do this? Because right now we have within our board, the evaluations are not done by anybody with a nursing or medical background. The analysis for cases is done when it goes to the board. It is done by somebody who has been trained in analysis for a day. It is not. It is not an analyzed. So that analyst decides whether it should go to an expert witness or should be dismissed, or that kind of thing. And that concerns me because I also represent clients in Arizona. And in Arizona, the Board of Nursing, if I have an MP client, I have an MP investigator.
Right.
So they understand what I'm saying. And it's not that the investigators are bad people or bad, but they they are like investigators. Like if you go and make an complaint to the police department and they investigate, oops, sorry, something, then why is this not there? Then you know, they evaluate. So these investigators are investigators doing the best they can, but they have absolutely, no understanding. They can say this is black or this is white, but they don't understand. Like if you're trying to explain, well, this is what happened and this is how it occurred, that there were extenuating circumstances and that kind of thing. Well, they don't put everything together.
Right.
Whereas if somebody's a nurse practitioner or a nurse, they can say, oh, well, I've been in that same situation. So I
Mhm.
can see how this backed up or that happened.
Mhm.
And so they don't understand that. And then you send it to an analyst who doesn't have any understanding. And then it goes to the board. I mean, California gets probably around 500 cases a month. So that in a quick nutshell is what AB-890 is. So I don't recommend that anybody stop doing standardized procedures or stop anything that they're doing now until there's clarification when these can stop, who's going to
Mhm.
tell you to stop. If you stop the standardized procedures, are you going to have protocols, to determine when it's an emergent condition, and all of this. These are all unanswered questions.
Mhm.
Um, and I would assume that the board is going to keep us informed and, let us know when things are going to take place. But that's hard to say too, because we still have the COVID going on. So things have still slowed down in the government. Um, so I would tell everybody not to get too excited yet, and to just, follow what you've been following until you hear about absolute changes and when they're going to take effect.
Yeah, yeah. So I know when we've talked before, and I've talked to other people in California, um, and I know about, the lack of, defined scope of practice, and you still had to have the protocols and standardized procedures. And maybe I'm just, not getting it, but what's the advantage here?
Um, I think they're hoping that eventually MPs will be able to have their own practice. But again, they are going to have certain types of protocols in place.
Right.
Maybe it won't have to be as lengthy as the standardized procedures,
Okay.
um, because they don't, there's a definition, but you're still not sure of what they have in their mind. And you won't know until they say something. And the thing that makes me afraid too is if they don't specify something, then you could do something and get in trouble. And
Right.
so I don't see it as a great advantage at this point in time.
Yeah.
Personally and legally, I don't, because you still have to meet all of this criteria, jump through all these hoops, and maybe the advisory committee will advise them that they don't think this is good, or this should be changed, or that kind of thing, and they will listen to them. But there isn't any guarantee of that
Right.
at all
Yeah.
either.
And it's probably really too early to say, but when I keep hearing people tell me that this is full practice, this does not sound like full practice to me, not
No.
anywhere near, because already you had some of these things in place, but it also sounds like it might be almost more restrictions. This
Yes.
idea of having to take yet another test when all around the country, all we need is a
Yeah.
national certification through our
Yes.
certifying
hmm
bodies.
I agree. I agree. I'm afraid that it may be end up being more restrictive for MPs. That's what
Yeah,
frightens
that's
me.
that's what I'm hearing, and it just, boy, it makes me more
Okay.
sad.
But yeah, I definitely think things are going. I'm afraid it's going to be more restrictive. I really am. But again, it depends on the board,
Mm.
because the board was not supportive of full practice authority. Um, so I don't
What?
know.
So am I correct in that the board doesn't have an APRN representative?
It does.
It
I
does.
think, yeah, I think the lady that's the representative, unless they got a new one, the last one I excuse me remembered was a retired MP that they had appointed.
Okay.
So there's not, to my knowledge, an active MP on the board.
Okay. So, what this is telling me from my perspective is the work in California is nowhere near done.
Oh no,
And
no.
in fact, it may have taken a step back.
Yes, yes. And like I say, I think the hope was for the people that worked on the bill, and they worked really hard on this
Mhm.
bill. Was the hope that, if we can get this through, then maybe we can convince people, and if they see what's going on in other states. But we're surrounded by independent states. We're kind of, the
I
only
know
one
you're
in
the
a
only one on the
pocket,
West Coast.
the only one on the West Coast. So I think that's what their hope was, that, that if we can just get something through, and if we can get this committee going, that, maybe they'll look at things,
Mhm.
and, you know, not have as many restrictions going forward. So it's definitely in progress, but I'm getting emails and phone calls. So when can I start practicing independently? And it's like, not for a while. And definitely with the independence can't occur till 2023. But again, how are we going to evaluate MPs? How is this committee going to evaluate
Mhm.
MPs? How many are they going to evaluate?
Mhm.
What is the criteria? I mean, we don't know any of this. I mean, are they going to go to perhaps some of the MP programs and appoint, people from those programs who know what MPs do and that kind of thing? Or, like I said, are they going to have the man off the street?
Right.
I don't know. There's
Right.
no way of knowing because there's no specification.
No, and even though, essentially that's 2 years away,
Mm-hmm.
January 2023, let's assume we're just about to 2021, that's a lot of work to get done in those 2
It
years
is.
with everything else that is going
Mm-hmm.
on in the world, in the way that, um, rules and regulations just seem to drag on and on.
Uh-huh.
So it doesn't even sound like, I if I was in California, I would not be holding my breath
No,
for 2021, and I would just keep
2023.
doing what I'm doing.
Yeah. That's what you can do, because I would want to see everything in writing before I started changing my practice in any way.
Mm-hmm.
Because ignorance is no defense of the law, as they say.
Yeah.
So you can't say, "Well, I thought it's dead." They go, "Mm-mm, sorry,
Yeah,
we
that
don't
doesn't
accept
work.
that."
I don't know, just doesn't work.
And like I said, hopefully, maybe the advice, because it doesn't say when they're going to appoint the advisory committee. Are they going to do that before the end of the year, or are they going to do that starting the beginning of next year? And like I said, my hope is that with the advisory committee, maybe they can possibly get some things changed. But again, I'm not going to hold my breath on that
Yeah.
either.
Yeah. So, how, there's already multiple NPs in California that own their own nursing corporation. They have their
Mm-hmm.
own businesses. Um, and they're working by protocols. They have a collaborating
Mm-hmm.
physician. How is this is not going to, from what I'm hearing, it doesn't sound
Mm-hmm.
like this would really make a difference for them. They're still going to have, well, they're going to have more stuff in their
Yeah.
procedures, but other than that, they can still go forth and have these nursing corporations.
Yes, and the thing is too, they have to remember the patients are the physician's patients right now. If we get independence, then they'll be ours, but they're the physician's patients. So they're basically providing the services for the physician's patients. I mean, that's the way you have to look at it, because they're not their own patients. They can never be their own patients right now. They are the physician's patients.
So if I
And
was in Santa Cruz
mhm,
and I had my own nursing corporation
mhm,
practice, I
mhm,
have my collaborator.
mhm.
My patients are not mine. Is that what you're
Correct.
saying?
That's what I'm saying.
Okay.
They're his patients. So, and right now I'm involved in a case. What's unfortunate, it is a solo practitioner. Never be a solo practitioner. Never call yourself a solo practitioner, because the board goes up in arms. And the problem arose is someone said she's a DMP and she called herself doctor, and we've been going around and round about this for ages. I mean, chiropractors are doctors, optometrists call themselves doctors. Why can't we call ourselves a doctor when we have a
If you have a
doctorate?
doctorate,
Yeah,
right.
everybody else does. In a university, they call them doctors. And I said, well, what's on your name tag? She didn't have a name tag. I said, "Oh my God, that's the first thing you have to have. You need a name tag. And on your name tag, you put your name and then you put your credentials." And I said, "It is." And the thing that's a problem too is, like, I don't have my doctorate, but I go in and introduce myself and I say, "Hi, I'm Melanie. I'm your pediatric nurse practitioner, and I'm going to be taking care of you today." Never fails. They're walking out the door. "Thanks, doc."
Right.
I mean,
Right.
it's and so you can do everything, and especially this having to say this with Hispanic patients, they're still going to call me doctor. So
Yes.
uh
Yes. That's
I
always been the case. Always.
always, and it's just unfortunate, because she's doing excellent work, and she has a collaborating. She's done everything right, but you can't be in solo. There is no such thing as solo practice in California. Your practice is with a collaborating physician, a supervising physician. You don't have a solo practice. You don't have an independent practice, because the patients in actuality are the patients of your doctor. They're not your patients. Even though you're seeing them and you're treating them, they are not your patients. They are the physician's patients. So, anytime you say it's my practice, you can get in trouble, because it isn't your practice. You're seeing the physician's patients
So
and
even
you
in a
corporate.
nursing corporation, it
Hmm.
is not yours.
No,
I mean, I know in a
and it's,
medical practice, because the
mhm,
physician owns 51%.
mhm. It's not. It's yours, but it's not your patients. Your
Okay.
corporation is providing, it's incorporated to protect you and everything, but it's providing services for the collaborating physician.
Wow.
It's
Well,
not yours. I mean, it's yours, but it's not. I don't
Yeah.
know how.
I think this is so important for people to hear because I hear people always talk about being independent.
No,
And quite frankly, I think that's the wrong term because
sure,
nobody
totally.
practices
Mm-mm,
independently.
nope.
I
Mm-mm.
even though I had my own practices for years in Washington State, where we have full practice authority
Mm-hmm.
and have since early, we were one of the earlier states up there, it still wasn't independent. It
Yeah.
was I was autonomous and I still called
Mm-hmm.
on my colleagues when I needed them.
Exactly.
And that would, I think, would be a much healthier way to approach and look at practice, in my
Mm-hmm.
opinion, anyway.
Mm-hmm. Because even with your nursing corporation and providing services, you still need to periodically talk to the doctor and show that, yes, you are working with the doctor. It isn't an
Mhm.
independent practice.
Right,
There is no such thing.
right, right. Well, I don't think there is an independent state in autonomous, full
Yeah.
practice authority state.
Yeah.
Because, like
Right.
I
Right.
said, I could pick up the phone and talk to the cardiologist, the
Mm-hmm.
neurologist, whoever I needed to speak with on behalf of that patient.
And
And
what I have seen is MPs will refer or consult faster than physicians. If you have an FMP and a family practice doc, the family practice doc, like if there's a heart problem, they may fiddle around with it for a while before they refer to a cardiologist. The FMP, if they determine that they think there is something wrong, they won't fiddle around. They will refer out to the cardiologist.
mhm,
And I don't know why so many physicians and so many people don't understand that because we will refer much sooner than most physicians will refer.
yeah, yeah. Oh my goodness. It's so like I said, I've been hearing so much about what is it, AB-890,
Mhm.
but I wasn't quite sure. And now hearing from you, um, I'm not gonna hold my breath. Let's put
Yeah,
it that way.
yeah.
Yeah.
Cross our fingers and, hope for the best but that's all we can do. And right
Yeah.
now, we have on the ballot 22, which is putting forward for like Uber and Lyft. So I'm hoping that we do get something in next year for healthcare providers to exempt us. But somebody was telling me that even if they pass AB 22, that the legislature can still deny it somehow. I haven't checked on that, but I thought, well, that would be interesting.
Yeah. And so
Um,
for those who don't understand what this part is, we're talking about the clauses, the ABC test for independent contracting.
Contractor, yeah, and
Yeah.
I'm hoping that other states, you know, don't adapt it. And I'm not sure of any other states that have, but they say they are. And I'm just hoping they don't because it's going to be harmful to so many people.
Right. I was just looking at this yesterday before we're doing the recording because of a talk I'm getting ready to do. And the number of states that have adopted either all three of the ABC rules is growing. Some of them have adopted AB or
Mm-hmm.
AC,
Mm-hmm.
um, but majority, it seems like most states are beginning to adopt that. And, as we said before, it really comes down to, for the states, it comes down to money, to
Mm-hmm.
revenue.
Right. Exactly. Exactly.
Yeah.
So we'll just have to see what the future of this bill brings
Right. Right.
and hopefully some good things will come from it. And like I said, at least with the advisory committee, maybe they will be able to be more convincing that MPs don't need everything in writing all the time and
Right.
can actually provide these
And
services.
certainly not an additional test.
No, I mean
Especially for
we're
those of
test.
us that have been practicing for a few years.
Hmm.
I would hate to take a test.
Yeah, I am tested out. That's that's the way I feel. But we'll just have to see what they decide.
Yeah. So in the meantime, NPs in California, Don't throw away your standardized procedures.
Mm-mm.
And where can they make sure that they're keeping up with what's happening?
Actually, if they belong to CAMP, California Association of Nurse Practitioners, and
Mhm.
I recommend the MP I was talking to yesterday probably wouldn't have done what he did if he had belonged to the association, because part of the association, if you belong to them, you get like 3 15-minute sessions with me per year.
Really?
So, yes. So you can either pay me, if you don't belong, for 15, and my charges are 400 an hour. So you can, to pay CAMP, which is less amount, and you get 15, 3 consultations with me a year, is not a bad deal. And CAMP keeps up with everything. And if the majority of MPs belong to CAMP, then we could have additional uh, lobbyists, because we only have one.
Oh my,
And
for all of California?
we have CAMP only has one lobbyist. That's all we can afford. So we could have more lobbyists. With more lobbyists, we would be able to push through better bills for us. But,
Mhm.
Christy, our lobbyist, is just working full bore, and it's a very difficult position for her, because there's so
Mhm.
many things, like the AB-22 came up, and then we're trying to do this. I mean, it's an impossible job for one person.
For one person.
So if, if even half of the MPs belong to CAMP, we would have that much more money to get
Mhm.
another lobbyist, so Christy would have help in doing what she does, because hers is over a full-time job.
Right, right. And not only that, they'd have access to you.
Right. They would have
And,
access to me.
for people who think, oh, 15 minutes is nothing, let me tell you,
Hmm.
that's a lot of time. So much can be accomplished. I do for NPBO members, I do 10-minute office hours.
Mm-hmm.
We do them every other week. And if we get a huge amount of stuff done, even in 10
Mm-hmm.
minutes.
Yeah.
So
So
yeah, join if you're
yeah.
not. And in fact, with laws that pass like this, to me, that's even a more important reason why you need to join your professional organizations.
Hmm. Yep,
So
definitely.
anyway, we'll leave it at that. Thank you so
Okay.
much today.
Okay, you're welcome. Have a
Good
great
luck.
day.
Yeah, bye-bye.
Thanks. Keep your fingers crossed for us.
I will.
Okay. All right. Thanks.
So thank you once again to Melanie Balestra for sharing her information about what is happening in California. And I want to make sure that you head on over to npbusiness.com/podcast so that you can connect with Melanie. Over there, you will find the information for her website, for the links to the California Association of Nurse Practitioner. And I highly encourage you to go ahead and check those things out. This is a topic that is far from being done. The rules are not yet written. And so this is crucial for you, particularly if you're in California, to keep up to date with what is going on. So I want to thank you for taking the time out to listen and or watch this particular episode of the NP Business Podcast. This is Barbara C. Phillips, nurse practitioner and founder of Nurse Practitioner Business Owner. I look forward to seeing you on the next episode of the NP Business Podcast. Bye-bye now.